should be relatively easy. So, Jen, can I start?
Sure. Well, thank you all for coming today. And having the mic present already. It says on. Great. Okay. Can you all hear me? Recording. Okay. So we're here today to talk. Ken gave a pretty good overview of something that the Legal Legacy has called tools of the trade, which I like to summarize as things to help you. The methods, strategies, documents in some cases to help achieve planned giving, which is different than giving a donation now. It's planning to leave something in the future. We've broken that down further into revocable and irrevocable, and as you know today, Dave and I are talking about the revocable tools of the trade that are out there and available to you and may be appropriate for various donors that you come across. And I kind of threw this at Dave, and he's going with my structure, so thank you. I broke that revocable down further into the probate type documents, processes, and then the non-probate tools of the trade that are also out there. So we're going to talk first about the probate options that are out there. And the big distinction between the probate and the non-probate is really the means by which the asset itself goes from the donor, the owner of the asset, to the beneficiary, whether that beneficiary is an individual, a charity, or whomever it's ultimately going to. The probate process is how it gets there, which can sometimes take a little longer than if it's a non-probate asset. And there's also fees involved through the probate process. So we can talk a little bit more about that as we go, but Dave's going to start off by talking about one of the most popular probate tools of the trade out there, the last will and testament.
Right. Hopefully you all know what a will is. You all have a will. If you don't, a will allows you to appoint an individual you trust to be the executor of the estate. The executor is the person who actually administers everything when you're gone, so it's someone that you hope will have the ability to at least categorize what it is that needs to be done and then actually get it done, and possibly retain counsel who would assist in the actual administration so that certain timelines are going to be met through what Jen described as the probate process. A will also allows you to appoint someone whom you know and trust to be the guardian of your children. If you're, the surviving parent and then you pass and there's no one actually to take care of your children or the person who is dependent on you, you can appoint a guardian. Ultimately, it's for the court to say who the guardian will actually be, but if you nominate someone in your will, then at least you've given the court some assistance in determining who that individual should be. Obviously, a will allows you to identify what it is that has value to you, whether it's monetary value or sentimental value, and you can designate individuals to receive that. And as attorneys, we use three different terms in the will: gift, I give, devise, and bequeath. That's because we get paid by the word. No, that's not true. So a gift is usually money, a bequest is usually something, and a devise is land. So if you give, devise, and bequeath, all the rest, residue, and remainder, I don't know exactly how we can distinguish rest, residue, and remainder. Maybe we did get paid by the word at some point, but that basically is the residuary, in other words, the things that go after you make your specific bequests. And ordinarily, in the way in which I prepare my wills, I do it like a checklist. I do, pay all the debts and expenses first, and then you have your specific bequests. I leave my watch to my son, I leave my drum set to my other son, and then they can decide, well, gee, I really didn't want that, and they can make their own agreements. So the will isn't necessarily, even though it's enforceable, but you don't necessarily have to abide by it. It can be subject to a family agreement. So if the one son says, I really like the watch, I'm not going to play the drums, how about we switch? I mean, you could ultimately do that. So after you do all your specific bequests, then you get to your residuary. One of the things that I do when I actually meet with a client is I tell them what a will does not control. A will does not control a variety of things. And this is a concept that even my sister, who worked on Wall Street, did not understand. A will does not, and I'm not using this in a political sense, a will does not trump everything else. So regardless of your political affiliation, a will doesn't actually act on anything for which you have a contractual beneficiary designation, like an IRA, which is an individual retirement account,
or an annuity, which will probably have a designated beneficiary, or what we call, and what was set forth in the ad for today, PODs, TODs, ITFs. PODs are just things that are payable on demand or payable on death. TOD is transferable on death. TODs are many times used by investment counsel who would basically say, you know, in order to avoid probate, you can have this stock go to this individual without having to go through the probate process, so that they actually have that. We as attorneys kind of look at that and say, it's still taxable. So if that asset has already gone out, depending upon who's actually going to be paying the tax, how is it that we're going to be able to pay the tax on that particular asset? So, and the other thing about stock transfers is if you have a stock transfer, ordinarily you'll be getting some sort of a waiver from the Department of Revenue here in the Commonwealth of Pennsylvania to actually allow for the payment of inheritance tax on the value of that asset as of the date of death. ITFs were another thing that was in the literature that was sent out to basically say what it is that wills don't necessarily control. ITFs are in trust for accounts. Banks will use these many times. Well, here I'll actually read from a case that describes what an ITF account is, and it uses another name called a Totten trust, which you might hear an attorney refer to, but one who deposits money in a savings account in his or her own name in trust for another establishes a Totten trust. It derives its name from a case back in 1904, In re Totten, which was a New York case. The New York Court of Appeals decision is basically saying that this is called a tentative trust. I use that in quotation marks. It allows the depositor to retain complete control of the fund during his life and yet secure the beneficiary any balance standing in the account at the death of the depositor. So these ITF, in trust for, Totten trust type accounts are also referred to as a poor man's will, because the idea is that it shifts the money at death to that individual. It is a judicial creation, but the banks, if there are any bankers or people who have worked with bankers, will know that ITFs are quite frequently used by individuals to make sure that the money goes to this individual or that individual. Again, the problem is if they think that the will make it so that everyone gets an equal share, that is not going to happen. I'm one of 4 children, so if my mom were to have left all of the bank accounts payable to me, that'd be really nice, in the hope that I would then care for Eric, Ruth, and Esther, my brother and 2 sisters. While I could do that, I wouldn't necessarily do that, depending upon what my financial need might be. And so the will, even though I drew the will, 4 equal shares, the will has no effect on those ITF accounts. And they are revocable because during the life of the depositor, the person could go in, either take all the money out or change the name of the person to whom the beneficiary would be. So these things are revocable. They can be revoked. To get back to what a will does do, and if you have not done your will, you probably should. A will is something which one would hope you're going to look at throughout your lifetime, not just say, well, I did that. I don't have to look at it any longer, because things will change. Life changes. People die, people move away, people are no longer in favor in families because they've done something to upset someone. And so if those types of changes occur, you should at least take your will out every 5 years or so. And in fact, I send a letter to my clients basically saying, you know, 5 years has passed, can you believe? And maybe we should take a look just to see how everything is going. And if everything's fine, then that's great, and then we'll just contact you in another 5 years. But you know, any significant change in your life, whether you lose the job which had the retirement account or something along those lines, you might want to take a look at what your will actually does do. If you were inclined to avoid going to an attorney, I just want to bring to your attention a case that occurred 8 years ago. It's In re Estate of Shelley, where an individual actually tried to write his own will on the back of a cigarette carton. Well, what he did do is he identified it as his first and last only will. He did have the word draft on it, and the court went through gyrations to determine whether that actually meant like first draft, rough draft, just draft, and the like. But because it said first and last only will, and it actually had some assets in it, which he said, let me see if I can find it, farm machinery and machines and tools. And then he identified the individual, Michael Cook Sr., living, my age. And then he identified other things to say, money, divide. Of course, he spelled it D-E-V-I-D-E, and they said that probably is divide. And then he signed it at the end. So to some degree, people were like, okay, well, this is a will, because he identifies what it is that he has. And in order to be a will, you have to know what you have to know who the natural objects of your bounty are, in other words, who you want to give it to, and then have some sort of disposition of the assets. Those three things basically make a will so long as you sign at the end. This will was offered for probate. As Jen mentioned, it's a probate document. Probate just means to prove. It's just from the Latin to prove that it is in fact your last will and testament. It was accepted by the Register of Wills, the individual who's at the courthouse who actually accepts the will and then grants the letters for the administration of the estate. And if you have a named executor, then the letters are letters testamentary because it's last will and testament, so that's where we get the letters testamentary from. And if you don't have that individual named in the will, or if you don't have a will and it's an intestate estate, you get letters of administration. Well, in this case, when the cigarette carton was actually offered for probate, the register accepted it, and it took a lawyer to then say, I represent the now intestate heirs, the individuals who are not in this will, to challenge the cigarette carton as a will, and to say just because it has the signature of the fellow, says last will and testament, and says divide the money, it doesn't say to whom the money shall be divided. It doesn't say in what amount the money shall be divided. And so the court on appeal basically said this is not a will, and so struck it. So going to an attorney sometimes can be expensive, but we do have some knowledge in this area, and so one would hope that we can, at least give you a product which will in fact serve your needs, identify what it is that you want to do, to whom you want it to go, in the amounts that you would like them to go, and then really for the benefit of all of you sitting here, one of the questions I ask initially is, in that specific bequest, in that checklist that we do before we get to the rest, residue, and remainder, is there something in which you're particularly interested in your life? Have you had someone die of cancer or heart attack, or do you have pets? Do you really like, some particular institution, whether it's a school or something like that you've been, like church, giving to regularly, possibly weekly? And would you want to continue their work through your specific bequest, or possibly leave the rest, residue, and remainder after you've given those things of either sentimental or family heirloom value to your friends, relatives, and descendants, to leave money to charity? I know Brad Jacobs, who's not with here today, has written extensively on the subject of making charitable contributions because of the tax savings that you will have, because in a will, in the probate process, or even in a trust, you will still have taxes to pay. So without too much longer, I'm going to turn it back to Jen, and she can Continue, yeah.
I won't say wrap up because you might be back here.
Yeah.
Continuing on with some of the probate process and the will itself, and how you can use a will to benefit some of you all in your organizations, your charitable organizations. Dave talked a lot about individuals and family. You can also benefit charities under your will aside from the specific bequest, or the residuary. You can leave items of property in your will. My rare art collection could go to Dream Rights to be displayed in their hallways, or however I want them to use it, I can dictate that in my will, which is really nice because you do have that flexibility to both dictate and control where you want the product to go and how you want it to be used to some extent, and you can change your mind. And that's what's nice about any of these revocable instruments. I don't know, people in my generation and people in my family and friends, they like to change their minds a lot. So the idea of saying you're going to do this and it's irrevocable and you can never change it, that's not appealing to them, but something that they can look at every 5 years and update and change if they don't like the mission of a particular organization anymore or the leadership or et cetera. They can change that beneficiary. They can change the amounts. They can give more. So your will is definitely a great tool to do that, either by a specific bequest or a residuary amount or specific items of tangible personal property. And your will does allow you to have some control as to how it's used as well. You can, if you're leaving cash, for example, you can dictate that you want it to be used for the building fund or at your church for the youth organizations or to build a new wing in an organization. You can name that in your will. You don't have to just say, here's $50,000 to do what you want with. Or you certainly can say that. But the option is there to maintain a little bit more control with your gift. And that's nice for donors. You know, they have that sense of control in some way that they can do easily and with the flexibility of changing. The other option that you have in using a will is to establish a trust within that will. And we'll talk a little bit in the non-probate side on living trusts, but you also have the option, if you'd like, to set up a trust under your will, which doesn't get funded during your lifetime. It doesn't even get funded unless you actually have the assets there to fund it with after the probate process and the payment of inheritance taxes and everything else. But then once it's there, you have the framework of your trust all set up. So you can say, I want this much money to go to this charity, I want this much money to go to this individual, this much money to go to you can name various charities based on the percentages. You can doll it out over time. You can designate a trustee that makes the discretionary distributions. There's a lot of flexibility, even more so than you have with just the language in the will, if you set up that framework in a trust format under the will. And I would 100% recommend talking to an attorney if you're looking at something like that. Because if the cigarette carton was any indication, there's a lot of nuances and language that needs to be in the document to accomplish those purposes, but they can certainly be accomplished to your donor's specific desires and wishes when we are aware of that up front and when they are put into writing. They're really powerful tools, even if they are revocable, when used correctly and effectively, really. So that's really all of the probate type documents that I could think of. I don't know if you know of any other than wills and trust under the will. Everything else that Dave touched upon is everything your will does not control. So your beneficiary, your life insurance, your 401k, your 403b accounts, your IRA, your in trust for, your TOD, your POD, all of those things don't fall under your will, as Dave touched upon. But they serve a really great purpose of benefiting whomever the beneficiary is without any extra paperwork, any extra time, any extra expense. And by naming an individual, you can likewise name a charity. So for any of these things, a bank account, a CD, an IRA, a 401k, you can designate a charity or an organization as the beneficiary of those items instead of doing it in your will. Whereas you come to the lawyer to do the will, I would talk to a financial advisor to set something like that up because they can help you get the right language in your beneficiary designation forms to make sure that it conforms and it actually gets to where it needs to go. But that can certainly be a great tool because then you do save some taxes, inheritance taxes, estate taxes, income taxes. There's a lot of taxes that are going around here depending on the asset itself. And when you're looking at naming a charity as the beneficiary of those things, you can avoid a lot or all of those taxes that would otherwise be paid when the person passes away. So those non-probate tools and the probate tools can be really helpful not only to accomplish your charitable intuitions and desires, but they can also save you a lot of money when it comes to taxes, which in the end may be someone's primary goal. Yeah, they like the organization, but they also like to save money. So if they could otherwise give a larger gift to an organization by using some of these tools than they would have given to the IRS or the Department of Revenue, it's at least worth the discussion sometimes. So we just wanted to make you aware that there are these tools out there that can accomplish that. Some are through the will, the trust, and some are as simple as changing a beneficiary at the bank, through your financial planner, through your employee benefits department. Wherever your documents are, they can certainly be updated at any time, changed at any time, and revoked or amended in the future. And that's what's really nice about these revocable instruments. Anything else to add at this point?
Sure. Yeah, taxes. What was it, Ben Franklin? Only thing certain about life is death and taxes. Taxes, where to start? Jen mentioned, let's see, inheritance tax. Pennsylvania is one of about 15 states that actually has an inheritance tax separate and apart from the federal estate tax. Everyone hears about the death tax and what the current administration is going to do or not going to do to get rid of the death tax, which they mean the estate tax. The estate tax is for those individuals, and hopefully you have many of your donors who are in this category, who have $5.45 million or more. That would be really nice. Very few of my clients have that, so we don't really talk too much about the federal estate tax. And so the individuals then say, well, what other taxes? And the Pennsylvania inheritance tax, everyone gets taxed, but the tax is based on the individual's status. So spouses are taxed at the 0 rate. Lineal descendants, that's in this line, up or down, parents, children, and the like, are at 4.5%. Siblings, basically horizontally, are 12%. Other people are 15% unless they're a charity. And if you're a 501c3 charitable organization, then the tax is 0. So that discussion, again, kind of dovetails with, well, what is it that you're passionate about? What is it that you want to do? And how is it that you want to have this particular entity continue the good work that you've been funding throughout your lifetime, now at your death? Would you like to make a specific bequest or a contingent bequest? It could be contingent on if so-and-so is no longer living, and then I give, devise, and bequeath all the rest, residue, and remainder of my estate to X charity. So, I mean, it can be contingent on triggering on some particular event that would occur. Yeah, the estate tax is pretty hefty, 40%. So, so there's the inheritance tax, the estate tax. There's also income tax. And a lot of our clients nowadays have a lot of their assets in IRAs, individual retirement accounts. And those accounts are, for the most part, traditional IRAs. In other words, they were used as a tax deferral method. And so upon distribution to an individual, which it can be stretched over time, you can make it into a stretch IRA, but ultimately there is an income tax component to the required minimum distributions that must be taken at 70.5 and beyond. So if they don't have the Roth, which is the pre-taxed money that goes in there, and so there isn't an income tax component, the income tax could be a means by which to have that discussion. Well, do you want all that money both in income taxed as well as inheritance taxed, if not estate taxed? And if they have significant funds in their IRA, then they can designate an individual, again, revocable, because you can change the designation at any time, or a designation, and again, a will, if you say in the will, and I don't really want that individual to get the money in my IRA, well, that's not going to happen because it's going to go by the contract. The contract and the contractual beneficiary designation is going to control. You can basically sell the idea of having a charity get that amount or a portion of that amount because it will be ultimately inheritance tax free. So that's if you're having this conversation with your prospective donors, that's at least one place to start. There's capital gains tax too. Go ahead, Dan.
Can I ask about making a charitable organization beneficiary IRA? Is there any downside to that from a tax point of view? Not subject to inheritance tax.
Well,
is there any income taxes payable? And
Assuming that the charity is in effect a 501c3 and it won't have any tax from inheritance point of view, I don't really see the downside just off the top of my head. I know we had a little discussion with regard to whether or not if trusts and whether or not, there were certain things that could be done in that context, but again, ultimately the tax component of it is going to be a zero effect for inheritance tax purposes if the charity is designated as the beneficiary of the IRA or the 401.
In a situation that someone's over 70 and a half and taking RMDs and names a 501c organization, charity of his IRA, maybe he splits between his children and the charity. The children have a stretch on the IRA.
Children can have a stretch.
But the organization does not. Is that correct, or do they have it?
Depends on how they're going to be, yeah, and if they're all three primary, like 2 children and 1 charity, then the question is, can the 2 children take their portion as a stretch, or are they somehow precluded from doing so because you've also got the charity in there which will not be able to stretch because it's not a human being. You have to have a human being in order to have a stretch.
Just the charity doesn't have to go through the stretch either. Doesn't have to go through the stretch because it's not.
So the question was whether or not there were.
Does the charity have to do a stretch in inherited IRA or not?
Can't.
I don't know.
Right.
I just want to make that clear. That's one reason
Right.
to give those things.
Right. Can't do a stretch. But again, why would they want to? Because the whole idea of the stretch IRA is to make the RMDs payable over a longer period of time so that the income tax hit every year is less rather than having to take it out within 5 years, which would otherwise be the default for an individual if they didn't stretch it. If there's no income tax component to the charitable beneficiary, then they don't really care whether it's a stretch or not, and they'll take the money and say thank you very much.
And from a planning point of view, qualified, non-qualified assets, and you want to make a contribution to a charitable organization, your recommendation would be qualified or not qualified. And you got children as well. Because the qualified gets taxed, non-qualified, assuming it doesn't have like access to it.
Well, again, qualified, again, the decision there is because it's qualified because it's under the Employment Retirement Insurance Security Act, ERISA. That has aspects to it of spousal interest and whether or not the spouse will have waived their right to a joint and survivor annuity. So, I mean, once you get through all of that, I don't know that I would make a recommendation. If they wanted to make it work, I'd find a way to make it work.
I just see people with qualified, non-qualified assets.
As between the two, which one would I?
Well, conceptually, I will say, this is going to, the qualified is going to be taxable, non-qualified, get stuff on the basic.
True.
And so it's a real advantage of leaving non-qualified assets to children.
True.
Qualified.
True.
Leaving qualified assets to the charitable organization.
And I was kind of getting to that in terms of the capital gains that you might have had either on a stock or a piece of real estate or something along those lines. And if that has appreciated, then the capital gains will be on the difference between what your tax basis was. Like my parents bought their house in 1961 for $17,000, and when it sold, it was $200 and some odd thousand, and so that could have been capital gains, but for the fact that that was their primary residence, and so therefore you didn't have the imposition of capital gains tax. But if you had an asset like stock or some property that isn't your principal residence that will otherwise be subject to the exemption, then you might want to make a gift of that property so that you wouldn't have that capital gains in life if you were to otherwise dispose of it. And of course, a gift isn't really revocable. We should be talking about gifts, right? Because gift is delivery and intent. So you can't just say, well, I intend to give it at some point. You actually have to give it, yeah? You can't say, well, I'm going to keep it here for a while and it's going to stay in my house, I'm going to enjoy it, and then hopefully they know that, yeah, well, that was mine.
But the stock account, you could use a TOD or a POD designation on your brokerage account that perhaps contains some stocks that would some appreciated stock that would otherwise suffer or be impacted by capital gains to an individual, but a charity wouldn't be impacted by that. So perhaps a TOD or a POD designation would be helpful on that account.
The only other point that I was going to mention with regard to tax is that if you have trusts, and if the trust is in fact revocable, and it's a funded revocable living trust, just because you put those assets into that trust doesn't necessarily mean that they're, well, it doesn't mean that they're not going to be taxed for inheritance tax purposes. The IRS, the Department of Revenue, views funded revocable living trusts as will substitutes because if you take an extreme example, if I am the settlor, in other words, the grantor, the person who sets up my trust, and I'm also the trustee, and I'm also the beneficiary of my trust, it's kind of illusory that there's really a trust there. I mean, in a sense, trusts are, I create a trust for Jen for the benefit of her children. She's the trustee. So, I mean, you would like to have three distinct settlor, grantor, trustee, person who's making the trust and funding it, person who's administering the trust, the trustee, and then the beneficiary of that trust. Will substitutes are basically how the living trusts are viewed, and actually when this was kind of hot and heavy years ago, the Attorney General's office was basically sending out something, and I have a number of these here if you'd like to look at them, The Truth About Wills and Trusts, because there were individuals from the King of Prussia area who were basically trying to peddle living trusts because they could charge $5,000 instead of a much more modest fee to create a will. Maybe those trusts would have been funded, maybe not, and if they were funded, the idea is that they were being sold on the idea to avoid probate, and in people's minds they were thinking, oh, avoid probate, I don't have to pay the government tax. Well, it doesn't work out that way. And if the person was sold on that idea, and then when the trust was actually triggered because of the individual's death and they didn't pay the tax, then you've got at least interest if you haven't paid the tax within 9 months, possibly penalty if that were be imposed either by the Department of Revenue or by the IRS. So you're putting your trustee, your successor trustee of your living trust in a position of making sure that he knows that there are taxes to be paid and timeframes in which to pay them. But again, this is from years ago. That individual has since been disbarred, and hopefully nobody has picked up from where he left off, and so we're not dealing with that. But it's a nice little handout if you'd like. I have enough for everybody here in the room, and you're certainly able to take that.
Yeah. And I will say the revocable living trust, I didn't really talk about that in the list of non-probate assets. We talked about the trust under will, which is establishing it under your will, but the revocable living trust, if you do set it up during your lifetime and you do fund it and you do name beneficiaries, it does serve as an effective tool to get those funds to the beneficiary during your lifetime without the probate process. You do still have taxes if the beneficiary is an individual, but if it's a charity, again, you're avoiding those taxes, and the revocable living trust is a way to, again, give some control, some guidance from your donor as to who you want to receive the money, when you want them to receive it, and how exactly you want it to be distributed. So it can be a very effective tool when used correctly by people that know what they're doing and not some guy in King of Prussia pretending to give you something that you're not really getting. So with any of these tools, you need to understand what it is accomplishing and what it's not accomplishing. And if you have a person in front of you that wants to accomplish a goal of some sort, we'll find a way to get there. There's a tool for whatever the end result is. It's just figuring out what is the appropriate tool for that particular person.
So speaking of this, is it appropriate for you to go a little deeper? I have people who come to me and they think they need a trust. It sounds more like all they need is a charitable gift annuity because they want income during their lifetime, and then what's left passes to charity. But they think they need a trust because that's more common and it's commonly talked about. So under what circumstances is it really necessary for a person to create a trust that would be a charitable remainder trust that would take care of a family member during their lifetime or after the spouse passes, versus they just need a gift annuity so they have income?
Yeah.
And the question was basically, when is it appropriate to use a trust versus an annuity, and specifically looking at a charitable remainder trust versus a charitable remainder annuity, or in the broader sense, when do they need a trust at all?
However you feel.
Okay. Well, I'll first give you a very lawyer answer that says it depends. It really depends on the individual. Secondly, some of what you're talking about will be covered in our next segment of this Tools of the Trade, from what I understand, because a lot of those are considered irrevocable. Granted, they can be changed to some extent, but from what my understanding, and I will admit it's a little more limited, on the charitable remainder trusts and charitable gift annuities is they are meant to be a little more irrevocable. They can be changed to some extent as far as who the beneficiary is, but once they're established, they are what they are, and there's not that flexibility that you have with a revocable trust. But to answer your question as to when does someone really need a trust, the answer is not as often as you think. I mean, people come in all the time and say they want a trust, and I'll sit down and say, what is it you want to accomplish? You know, who's your family? Who do you want to benefit? Is there a charity you have in mind? We'll have these discussions that Dave said that he has with his clients. We all have those to figure out really what do they need in the end. And sometimes there is a little bit of trying to bring them, centering them and getting them to come into focus as to what their goals are, and then steering them into a better direction to accomplish that goal. But the short answer is it really depends as to whether a trust is right for an individual or not.
Yeah, years ago, there was a guy who wrote in the real estate section, if you get the Sunday paper, Bob Bruss, and he was always promoting trusts because he lived in California, where I imagine the probate process is more difficult than it is in Pennsylvania. It really isn't very difficult or expensive in Pennsylvania to probate one's will. If you actually had property in a variety of different states, let's say you had a Delaware beach house, a cabin in Vermont, maybe someplace in Hawaii, you know, that'd be nice. Let's just think large. You know, then you might want to avoid probate in each of those jurisdictions, whether there's actually tax in those jurisdictions or not. I mean, Delaware has some form of an estate tax that, my recollection, mimics, although I'm not licensed to practice in Delaware, it mimics the estate tax in Delaware. So if you wanted to avoid probate, because in order to transfer the property in a particular state, you're going to have a deed, and in order to do the deed, you're ordinarily going to have the executor issue the deed. You know, Dave Mills is executor of the estate of so-and-so deceased to grantee, and in order to do that, in order to have that power, you have to probate. So the trust can actually get the property into somebody else's hands without having to do that, and without having to create, if the person dies domiciled in Pennsylvania and has that Delaware property, you're going to have what we call ancillary jurisdiction or ancillary administration in Delaware to actually do the same thing in Delaware through the executor that was appointed in Pennsylvania. So if you had someone who had, you know, a variety of different places, and then you have to figure out, well, where do they actually live? Because, you know, we have snowbirds, and, you know, 6 months here, 6 months there. Do they have that homestead exemption down in Florida? You know, are they really a Florida resident? Are they really a Florida domiciliary? Should they really be seeing a Florida lawyer? Or are they Pennsylvania? And there's a case on that too, Perlman out of Philadelphia, where the guy who, it's Revlon, he and his wife didn't necessarily get along, and so the lawyers involved basically did not have that standard language, you know, I, David Mills, a resident of or domiciliary of Springersbury Township, York County, Pennsylvania, which kind of establishes what your domicile is. Domicile is where the heart is, not necessarily where you're physically, permanent residence, whatever. So yeah, there's a distinction is between domicile and residence. So was the wife a domiciliary of Florida, or was she, well, luckily, they had enough money that, you know, you could pay all the lawyers and they could fight about this in Philadelphia County Court. So that was nice for us. But I mean, really, so depending upon what you wanted to accomplish, and I think that's really Jen's point, is there really a good reason? Now, I can tell you there's probably a good reason not to have a trust sometimes. Like if my property, where I live, and I'm a domiciliary of Springersbury Township, if I were to put the property that I own into the Dave and Barb Trust, well, I pretty much lose my protection if someone were to sue me and then say, well, this is an illusory trust because you're both the settlor, beneficiary, and the trustee of your trust, and now I've got someone slipping and falling on my sidewalk, and I only have, or maybe I have a car accident and I only have Safe Auto, okay, so now I got $15,000 for this, and the person has horrible injuries, they're gonna go after other assets. Well, if it were just me, they wouldn't be able to touch my house because my house is held tenancy by the entireties. Barb and Dave Mills were a unity of interest, and so you'd have to get judgment against both of us. I'd have to be driving Barb's car, when I actually did something for them to get judgment against both of us. You put it into the Dave and Barb Trust, it's basically not, it's no tendency by the entireties, because we don't have trusts marrying each other. We have, it's a separate entity. So, I mean, you have some liability concerns if you put things into a trust without really thinking it all the way through.
Your example of real estate in different states is really the only example that comes to mind too, is when you need a trust, or not even need, but it's really recommended.
It might be a good idea.
Yeah, I like that domicile is where the heart is. I kind of want that in my office. Never heard that one before.
Yeah.
I like that.
Home is where the heart is.
Yeah. So I think we've covered most of what we intended to cover. So are there any other questions that anyone has? Or does Dave have any more war stories?
Yeah, war stories.
Well, actually, right behind you, Dave. We have somebody behind you.
I have a question about, you mentioned the beneficiary designations are not part of the will. So, and you were mentioning that people of your generation, actually everybody, really likes to see their gifts go to a particular institution and used in a particular way. Is there a way to make sure that happens with a beneficiary designation tool versus the will?
Not to my knowledge, and that's where the pros and cons of both ways, you go the probate process with the trust or a will, you have that control, that flexibility to dictate one step further what is done with that money. On a flat-out beneficiary designation, you really don't. That's not to say you can't provide instructions, in an ancillary document of some sort to the organization. Like, look, I've designated you as a beneficiary. Here's my thoughts and my wishes and my desires as to how it be used. It's not enforceable in court, obviously, but it's at least getting the thought out there, the intention out there, but no, just a flat-out beneficiary designation, unless you know otherwise. I don't think can accomplish that.
I know York College actually has some sort of an intent to give type thing, which may actually be one of your, what you were saying, additional pieces of paper that says, this is what we really want it to be used for, the Dave Mills wing of...
Yeah.
Okay.
Yeah.
I'll get the check from him later.
You need me to sign that.
That is what we do at the Jewish Community Foundation. People come and talk to us, we're a foundation for whatever you care about, not for the foundation. And we actually sit with the donors and they sign very specifically exactly what is supposed to be done with that money when we receive it. And so when I go to see their lawyer, they just put up here bequeathed to the foundation, but that signed document with us, the lawyer gets a copy of that, the family gets a copy of that, whoever we want to have it, we have a copy of it. And that tells us when the money comes to us, this is what you're supposed to do. And it even has a...
I was just going to say, and the Community Foundation has donor-advised funds which are similar to that.
But also our letter of instruction can be used for somebody's beneficiary designation form.
Yeah. So it looks like it's always some sort of ancillary document that you might need to go that next step. When you go to Prudential or whatever and change your beneficiary, you need to go that step further and go to the organization itself, I would say, to accomplish any further.
And that's the conversation that we have with the client that basically says, okay, you've done your will, but you've got all these other things that aren't going to be controlled by your will. You really need to pull out. And some clients are very, close to the vest. They don't necessarily want to share what it is that they have. I mean, I'm not a priest. It's not confession. And I guess they have some concern that they're telling this stranger, what it is that they do and don't have. I have a 10-page questionnaire that I'm very reluctant to send out because they all look at it like it's homework and it discloses everything. But it really would be better if I had better information as to who the beneficiary is of your life insurance, what kind of 401k or 401k, for those of you who don't know, if you're employed, it's your retirement fund, a 403b. What she mentioned is the same type of a thing for different professions. So there are. It would be better to know what all this is, and then to say specifically, you need to look at this, and I can't change this for you. Yeah. I mean, I guess I could contact them.
Well, and that helps direct the conversation that Dan was asking for with what types of assets should you leave to a charitable beneficiary versus an individual. And without knowing what your assets are, it's hard to guide and provide some suggestions. But if we do know all of that, we can help give some professional advice as to whether you should leave your IRA that's qualified versus non-qualified, and an individual versus a charity, and get into more of the discussion about the taxes and everything.
And I have a client currently who was told by his mother repeatedly that only 2 of the accounts that she had were ITF, in trust for accounts, in trust for him. And I said, well, if that is the case, then maybe we will probate, because you don't have to probate for everything. I mean, if you have, if the account has less than $10,000 on a receipted funeral bill, you could basically use that as a basis by which to get the money out of the bank. And if it's a small estate, you wouldn't necessarily have to go through the whole probate process of getting letters testamentary. You could use a petition for administration of a small estate if it's less than $50,000. Well, as it turns out, all 4 of at least this one bank's accounts were ITF. Now, there are other accounts, but it's like, really, I wish we had known this, but you can't get the information from the bank until you get the letters testamentary, or if you actually know, and we said, send us the statement, but the statement didn't say ITF, it just said, who the decedent was, so it's like,
That's one thing we didn't touch on is joint accounts too. The bank statements don't always show whether the account is my name with so-and-so as agent or my name with so-and-so as a joint owner, and that runs into trouble sometimes if people think that a certain bank account is going through their will. It's not. If there's a joint owner, it's going to that joint owner. Sorry.
And I'm sure you've all experienced this, banks gobble each other up. And while we dealt with smaller banks that you kind of knew what types of accounts they actually have, when the bigger bank comes in and you send out for that bank letter, now they're saying primary owner is so-and-so, secondary owner is so-and-so. It's like, what does this even mean? Who is the, is this an ITF account, or in other words, is it in trust for, and now we have beneficiary designations in it, or is it a jointly owned asset? Because for our purposes, if it's jointly owned, it gets taxed differently,
It's a Schedule F, it's a tax, yeah, right.
So speaking of bank accounts, a lot of older folks tend to keep assets in a bank account or in a safe deposit box and so forth. And they tell me lots about their lives. And
what's your secret? Yeah, right. They're not, you don't have the meter. You're not. Right.
I don't know. I have people that come with their list. I'm like, well, thanks.
Sorry.
the question then is, when they've got these bank accounts, sometimes they'll say the bank will only let me name one beneficiary on the form. So who's it passed to? They put a name on the form for the beneficiary. So if that person is gone and they forgot to do it, how do you help someone deal with, or how, what do you do with the fact that there's this asset and someone's dead, and how does that get resolved?
I'm not exactly sure what you're asking, but I have 2 stories. One has to do with
Where the beneficiary forgot to change the beneficiary, they die, and they didn't do a new beneficiary, so those assets are sitting.
Oh, if they don't have a beneficiary again, yeah. And if it is a TOD or a POD account or an ITF account, well, then it's just sole owner by the individual in whose name it is, and then it goes under the will if they have a will. If they don't have a will, then there's a whole intestate scheme by which the Commonwealth says, okay, if your spouse and if you have children from that union, it goes this way. If the children from a different union, it goes that way. And then if no spouse, then children. If no children, then parent. If no parent, then brothers and sisters. If no brothers and sisters, then, ultimately it could escheat to the state, but you got to go a long way before it escheats. My thought was, I've encountered banks that, let's say father and son have the same name, and they wanted to put son on as POA. Now, granted, POA laws have changed a lot, and banks are more and more reluctant to have their own designated powers of attorney documentation. So maybe this will be less and less of a problem, but they wanted to put son, junior, on as POA for dad. And it apparently went to the back office, and the back office said, oh, we don't have to do anything here because he's already on the account. Okay, so there was that issue. And then you have the issue of someone wanting to help out their neighbor, and so he puts he must not have communicated effectively, or the bank official didn't understand completely what was to be done. And I think they wanted to have the neighbor have that ability to write checks in case he was unable to do that, but they put her on as a joint owner. She died. It would have been taxed in her estate. It wasn't her money. And so you have to go through, okay, let's see what the original bank signature card is. Let's see whether or not they actually circled or checked off the correct box to say as attorney in fact or as joint owner. Because you'd like to think that when she was signing, she actually looked to see what the box was and checked off the correct box that she was to be POA. And if there is no check mark, and you can establish an affidavit from the surviving person that in fact this was my money, it was never hers in the first place, you at least have an argument with Department of Revenue that it shouldn't be taxed for inheritance tax purposes. I don't have the result on that yet, but it's pending.
Well, and just to elaborate further real quick, you can always go to a higher up person at the banks a lot of times, and beneficiary forms too. When you get your life insurance and there's a beneficiary form, it's, you know, like a square peg in a round hole trying to conform who your beneficiaries are sometimes. You can always call and ask for, you know, supplemental documentation or something. I'd push it a little further. If they really do want to name a contingent beneficiary, which I always recommend, a primary and a contingent, just maybe ask the manager of the bank instead of the teller you're dealing with. I just push a little further would be my advice on that. Oh, I'm sure. And CDs, a lot have huge amounts in CDs. And I have a lot of clients that like to name beneficiaries of those CDs as well. And it's amazing how much money they have just sitting there doing nothing. Just talk to Dan.
So on the last page, you have one thing on your life insurance beneficiaries. When I ask you questions, I want to make a statement of it. I found a lot of clients whose life insurance needs have reduced. They have policies they want to do something with. And I always ask the question, is there a charitable organization you might want to leave this to? Because they can do various things. They can stop paying premiums. But I think it's important that we don't overlook that aspect of naming a charitable organization the beneficiary of that life insurance policy. There's no current tax deduction for it, but the money passes directly. I've had a couple cases where clients have bought life insurance policies for charitable organizations, and when they die, the money went to the organizations. And it's really very, very much appreciated by the organizations because they get the money relatively quickly, larger amounts than they anticipated, and they're all very thankful for it. But I think that's something that we tend to, as my business, we tend to not ask about and overlook, is, by the way, the SEC don't want this policy, but it's an organization that takes the benefit of this life insurance policy. You don't want the cash anyway, and you've already left enough money for your kids, why not make an organization? So the charitable organizations here is something to think about. You can always ask about life insurance, and I've done some things with my life insurance. But let's also ask the question about naming the charitable organization beneficiary, because it does pass tax-free organization.
And probate free, I mean, that's one of the easiest.
You're not going through probate, it could get there much quicker.
Pennsylvania.
The residual assets to end up with the organization they have to be.
Exactly.
Pennsylvania does not tax insurance, inheritance tax.
As a direct beneficiary, right. Because it passes outside the probate state.
The federal government here.
Only if it's an estate tax purpose, they've got more than 5.4 million, right? Okay, so, you know.
Yeah, that's definitely, and we try to talk about that.
Although, in that situation, you're going to have ownership of it, the insurance going to own the policy anyway. I'm not going to have a situation to avoid the taxation.
Some people think, like, going back to why people think trusts are such a wonderful thing, they think that that's maybe part of the whole Medicaid planning. You know, I can impoverish myself by disposing of all my assets into this trust, and, well, you know, there's still a 5-year look back, and you have to have that conversation with them, so.
It's not a plan.
Yeah, it's not really a plan.
I think we hit on all the tools. Again, does anyone have any more questions?
Yeah, we don't need to keep you longer than you need to be.
There's lots of cookies over there still.
Yeah, they have my name on it, but I'll share.
Well, thank you all very much.
Thank you.
Oh, and